guys. Welcome to the semifinals round of the Philippine National Rounds of the 2025 Philip C. Jessup. Law schools from across the country entered the competition, and after 6 rounds of eliminations, 28 teams have now been narrowed down to just 4.
The judges are all unanimous in saying that the quality of debating has improved a lot for this year. So congratulations, everyone.
But before we announce the semifinalists, here's how the rankings were determined. According to the official rules of Jessup 2025, teams are judged on the overall quality of their performance, not on the merits of the fictional case. Scoring in the preliminary rounds is based on 2 components: written memorials and oral rounds. It's time to reveal the 4 teams advancing to the semifinals.
Most exciting part of the tournament, the announcement of the semifinalists. It's a win-loss tabulation. The most number of wins, of course, would have the highest rankings, and the top 4 highest ranking teams will move on to the advanced rounds or the semifinals. There are 4 rounds to win. So if you get all 4 rounds, you belong to the highest bracket. But there are 5 teams. All had 4 wins, 0 loss. We already have the top 4. And we will now be announcing the top 4 in their rankings. The rankings would be important because the highest ranking will battle it out with the 4th ranking team, and the 2nd ranking team will battle it out with the 3rd ranking team for the semifinals. In accordance with their ranking, rank number 1 is Team 444.
University of San Carlos.
Second place after the preliminary rounds, Team 109.
University of San Agustin.
The 3rd place is Team 665.
University of the Philippines.
And the 4th team and the final member of the top 4 semifinalists is Team 315.
University of Santo Tomas. Let the semifinals begin! In this first semifinals match, the applicant, University of Santo Tomas, goes head-to-head with the respondent, University of San Carlos, as they present and defend all 4 issues of the 2025 Jessup case before the International Court of Justice. The applicant's first speaker now takes the floor.
Madam President, Your Excellencies, good day and may it please this honorable court. My name is John Andrew Tenesio. I respectfully enter appearance on behalf of the applicant of this case, the Union of Ambrosia. I will discuss our first and second submissions regarding first, this court's jurisdiction to hear the claims of Ambrosia concerning Rovinia's arrest and prosecution of Ms. Cross, and second, Rovinia's violations of international legal rules on jurisdiction and immunity. Madam President, Your Excellencies, good day. Your Excellencies, respect for sovereignty is a fundamental legal duty under international law. It ensures jurisdiction is exercised within legal bounds, immunity for official acts is respected, and treaty obligations are honored in good faith. Without these principles, states would be free to impose their own authority whenever they wish, undermining legal certainty and international cooperation. And this is exactly what Rovinia had done in this case. For years, Ambrosia has taken actions in connection to the allegations to the ILSA program. Its Prosecutor General investigated, secured convictions, and even reopened Ms. Cross's case. But instead of cooperating to this process, Rovinia unilaterally asserted jurisdiction where it had no authority. In light of these...
Agent, does this court have any jurisdiction over the matters you have raised?
Your Excellencies, we submit that this court has jurisdiction since the matter of this case are subjects of international law. And on that regard, Your Excellencies, allow me to direct this court to our first submission on the matter that this court has jurisdiction over the claims of Ambrosia regarding Rovinia's arrest and prosecution of Ms. Cross.
Mr. Agent, is it not that the OCDP charter only took effect on March 17, 2021? And Ms. Cross acts which were tried in the courts of Rovinia only happened way before that.
Well, we acknowledge that point, Your Excellencies. However, it is our submission that this court has jurisdiction rationale tempori since this court or the dispute happened after the entry into force of the Article 21 of the OCDP Charter. We note, Your Excellencies, that the crucial date to determine this court's jurisdiction is on March 17 of 2021, when Article 21 of the Charter took or entered into force. However, Rovinia's acts that give rise to the dispute happened years after.
Mr. Agent, is it not that Rovinia is investigating Ms. Cross on the doctrine of universal jurisdiction because of enforced disappearance, which is a violation of the human rights? So how can you convince us that Rovinia really has no jurisdiction in this case?
Thank you for that question, Madam President, and this leads me to our second submission on the issue of whether Rovinia's actions indeed violated international legal rules on jurisdiction and immunity. And on this note, Your Excellencies, we submit that the act of Rovinia is unlawful because its exercise of universal jurisdiction is unjustified. We note, Your Excellencies, that a state cannot unilaterally exercise universal jurisdiction without first complying with strict legal conditions.
Haven't you found already the legal basis from the elements or the requisites that you cited? Has not one of these been, or all of these have been met by Rovinia when it assumed criminal jurisdiction over that arrest and prosecution of Ms. Cross?
Your Excellencies, on the matter of the threshold onto the exercise of universal jurisdiction, while it is our concession that enforced disappearance is a crime recognized under international law, however, the last two elements, such as the principle of subsidiarity and a legal obligation to prosecute the crime, are not present in this case. Thus, Your Excellencies, we submit that Rovinia's exercise of universal jurisdiction lacks any valid basis under first, the International Convention for the Protection of All Persons Against Enforced Disappearance for the ICPPED, and second, under customary international law.
While there has already been investigation in Ambrosia involving Ms. Cross, the Rovinia does not think that there would be acceptable legal procedure or remedies.
Well, we understand that we, Your Excellencies. However, we would like to clarify that Article 9, Paragraph 2 of the ICTPED provides that a state may assert criminal jurisdiction over an alleged offender should he be present in their territorial jurisdiction for crime of enforced disappearance unless it extradites or surrenders him to a state under its international obligation or to a recognized international tribunal. This means, Your Excellencies, that the phrase unless it extradites makes it clear that if an extradition request is made, prosecution under universal jurisdiction is no longer an option unless the request is denied for legitimate reason.
Extradition, request for extradition, is it indeed a mandatory, compulsory action on the part of the requested state? Does the ICPED really require that for the other party, in this case Romania, to validly legally exercise criminal jurisdiction over Ms. Cross?
Your Excellencies, while we understand the view, particularly the ICTPED committee recommendation suggests that the state party should submit any case of enforced disappearance to a competent authorities for prosecution despite of the existence of an extradition request. But in this case, Your Excellencies, Ambrosia and Rovenia are member states to an extradition bilateral agreement as provided in clarification number 5 of the records. Therefore, since the exercise of universal jurisdiction is strictly conditioned upon the principle of subsidiarity, therefore, that Rovenia must prioritize extradition rather than continue with its prosecution in relation to the principle of aut dedere aut judicare, which means to extradite or to prosecute. Allow me to direct this court's attention to our last submission regarding the entitlement of functional immunity to Ms. Cross.
But is it not that the acts committed are beyond the official ones? So how can you consider that as part of her official functions?
On that note, Your Excellencies, in order for Ms. Cross to be entitled functional immunity, 2 key elements must be established. First is a direct link to a state authority, and second, attribution to the state. And it is our submission, Your Excellencies, that these key elements or elements are present in this case. Because first, Ms. Cross was executing the ILSA program, which was a national security operation approved by the highest government levels of Ambrosia to combat insurgency and other problems in the Paine Peninsula.
Recognizing and even applying the functional immunity doctrine principle, it does not also, it's not covered, it's no excuse for illegal, unlawful acts. It's not enforced disappearances.
Your Excellencies, this is the reason why we seek this court's attention to not judge over the merits of the case of Ms. Cross if indeed enforced disappearance or Ms. Cross indeed committed the crime of enforced disappearance. And since Ambrosia is the most...
How would you characterize the crimes committed by Ms. Cross, Minister Cross?
The allegations against her, Your Excellency, is enforced disappearance, which means that there were transportation or there were deprivation of liberty of the persons involved.
Do these crimes rise to the level of a crime against humanity or a crime against all of humankind?
As provided in the ICTPED, Your Excellencies, it was recognized as a crime against humanity. And therefore, since the allegation is, and the gravity of the allegation against Ms. Cross is heavy, therefore it is important that Ms. Cross be prosecuted to a competent authority or competent state that has the capacity to bring justice at the end of the day.
So you are saying that, you can proceed, we can proceed with this last question. So you're saying that Rovenia is not competent to hear the case of Ms. Cross? And are you, Ambrosia, competent to do it?
Your Excellencies, on the matter of subsidiarity under universal jurisdiction, it dictates that the primary jurisdiction lies to the state that has the strongest nexus to the alleged crime. And since Ms. Cross was an Ambrosian national, a former Minister of Interior of Ambrosia, the victims were Ambrosian nationals, and the crimes alleged took place on Ambrosia. Therefore, Your Excellencies, that the territorial link or the nexus of the alleged or offense is present.
But can the victims be assured of due process when Ms. Cross is a high-functioning official of Ambrosia?
While we understand that there are there are views on that matter, Your Excellencies, however, Ambrosia is still committed to prosecute Ms. Cross regardless of the fact of she being a former Minister of Interior, since different perpetrators were already convicted. We submit that it doesn't negate the fact that there were already proceedings that happened in Ambrosia that would necessarily administer justice at the end of the day. If there are no further questions and clarifications for issues 1 and 2, Your Excellencies, I thank this court's time and indulgence and may it please this honorable court.
The semifinals competition continues when the Jessup 2025 Philippine Round Journey returns. The applicant's second speaker now proceeds to present the third and fourth issues.
Madam President, Your Excellencies, may it please the Court. My name is Ian Gabriel Kiambao, and I respectfully appear as the second agent for the applicant, the Union of Ambrosia. For the next 22 minutes, I will be discussing the third and fourth issue concerning Rovinia's issuance of fishing licenses in the Triton Shoal and the sale and seizure of the Falcon. Your Excellencies, the Peninsula's coastlines are receding at a rate of 1.5 meters annually, with forecasts indicating an accelerating trend. Among the affected states, Ambrosia bears the heaviest burden given its geographical exposure. As such, it poses not merely an environmental crisis, but rather an existential threat. To confront this challenge, Ambrosia enacted the Baseline Freezing Law of 2015, an act rooted in necessity and the rule of law. In this regard, Ambrosia respectfully submits that first, Rovinia's issuance of fishing licenses in the Triton Shoal violate Ambrosia's sovereign rights under international law. Second, that the Ambrosian Baseline Freezing Law of 2015 is consistent with international law. And third, that the act of freezing baselines is a legitimate regional custom within the Paine Peninsula.
How do you meet the argument of Rovinia that it is already in the high seas?
Indeed, Your Excellencies, Rovinia contends the validity of the frozen baselines, claiming that the portions of the Triton Shoal were already in the high seas. However, Your Excellencies, this interpretation stems from a rigid plaintext interpretation of Article 5 of UNCLOS. However, as indicated in Article 32b of the Vienna Convention on the Law of Treaties, recourse to other means of interpretation is warranted if the said plaintext or ordinary meaning approach would lead.
Don't you think the drawing of lines of exclusive economic zones is a technical issue and not subject to interpretation?
Your Excellencies, we would humbly disagree. As indicated in Article 31.2 of the Vienna Convention on the Law of Treaties, that the interpretation of UNCLOS must be governed by the preamble or the annexes, and as enshrined in the preamble of UNCLOS, the purpose of the said convention is to ensure equity in maritime governance. As indicated, Your Excellencies, in
You have authority for saying that the equity principle is governing under international law.
Yes, Your Excellencies. In fact, in the case of Bangladesh versus Myanmar, the International Tribunal for the Law of the Seas already departed from a strict interpretation of the Article 74 of UNCLOS, as it would lead to inequitable results. Now, as indicated, Your Excellencies, in paragraph 9 of the facts, the effects of sea level rise are disproportionate to the Paine Peninsula, with Ambrosia being the most affected and Rovinia being the least affected.
Is it not that the principle that we should follow now in because of climate change is that the baseline should be ambulatory? So how will you reconcile that with the baseline freezing law of Ambrosia?
This precisely leads us, Your Excellencies, to our next submission, that the that the subsequent agreements or subsequent practice of 6 of the 7 Paine states within the Paine Peninsula is pursuant to Article 31(3)(b) of the VCLT, which applies an evolutive interpretation of maritime laws.
And what is that exactly? Is there now a state or regional practice in that part of what's that? It's the peninsula, the Paine Peninsula. Can you cite to the court or an authority or?
Yes, Your Excellencies. Given that 6 of the 7 states in the Paine Peninsula have already enacted the same freezing legislations, we submit that this constitutes a valid regional custom.
But it's not enough. It's not sufficient. But I think for state or regional practice to be recognized, there are the elements of generality, of uniformity, and there's the third one. Are all of these present here?
Yes, Your
And can you cite what's happening in the Pacific Islands? What they have done in Fiji, something here. They have done that. Can you already cite that as the authority or as the model so that the court can sustain you that point?
Yes, Your Excellencies. As indicated in the asylum case of Colombia versus Peru, the 2 requirements for a regional custom is that of state practice and opinio juris. Both have been met in the case of Ambrosia's frozen baselines. For state practice, 6 of the 7 Paine states have already enacted freezing legislations.
But Ravinia is always consistently opposes that or objects to that.
Yes,
So if there is one who opposes or objects, can we say that there is that state practice? That's why I was asking you what are the requisites or the elements for state practice or regional practice?
Yes, in addition to the observation of my honorable colleague, there is also such a thing as the persistent objector principle under international law, and Ravinia has been a persistent objector under international law.
Indeed, Your Excellency, Ravinia may contend that the effects of Ambrosia's frozen baselines are not opposable to it due to its supposed objections. However, we submit that Ambrosia or Ravinia does not qualify as a persistent objector. Your Excellencies, as outlined in the asylum,
What is your basis for saying that Ravinia is not a persistent objector?
I would like to direct the bench's attention to paragraph 22 of the facts. In paragraph 22 of the facts, Your Excellencies, it is established that when Ravinia unilaterally issued the fishing licenses in portions of the Triton Shoal, Ambrosia sent 4 notes verbals explicitly protesting these actions and reasserting the validity of Ambrosia's frozen baselines. However, Ravinia failed to respond to any of these diplomatic communications. We submit, Your Excellencies, that this silence constitutes as a failure to abide by the consistency and clear expression requirement for that of a persistent objector. Now, Ravinia may contend that the act of issuing fishing licenses in and of itself was the objection, or was the objection by form of deed. However, Your Excellencies, we submit that this is not the form of objection that is contemplated by international law. I shall now proceed with the issue of the sale and seizure of the Falcon. Moving to the issue of the sale and seizure of the Falcon, on the 14th of July 2023, the Permala Court ordered the sale and seizure of Ambrosia's aircraft, the Falcon, an asset used for diplomatic and state functions. This sale and seizure, based on a purported waiver of immunity by the Transitional Council, an illegal and unconstitutional entity, violates the principles of sovereign equality of states, state immunity, and constitutional legitimacy. Customary international law recognizes governments based on 2 key criteria, either that of effective control or constitutional legitimacy.
In this particular case, was or is there any debate or controversy over Rovinia's having actually recognized the Transitional Council?
Indeed, Your Excellency, Ravinia has recognized the Transitional Council. However, as outlined in the Aguilar-Amore case, government recognition or non-recognition is not the primary consideration when it comes to determining the legitimacy of the government. It is either that still of exercise of effective control or constitutional legitimacy. In the recent
Agent, just indulge me on this. Would you concede that the Transitional Council did actually exercise effective control in Ambrosia?
Yes, Your Excellency, we concede that the Transitional Council exercised effective control. However, as reaffirmed in recent recognitions, where the international community recognized the constitutional governments despite the presence of unconstitutional governments exercising effective control, this reaffirms the position that even if the Transitional Council exercised effective control in the presence of acting President Zavala, the rightful constitutionally recognized leader, the Transitional Council cannot be considered the legitimate government of Ambrosia.
Agent, in the wake of the things that happened, how many states recognized the Transitional Council?
25, Your Excellency.
And how many continue to insist that acting President Zavala was the head of government?
15, Your Excellencies.
Thank you.
Now, this brings me, Your Excellencies, to the nature of the Transitional Council. We submit that the Transitional Council is not a de facto government. It is merely a provisional de facto government. As outlined in the rights of passage case of Portugal versus India, a de facto government is considered to be provisional when it exercises factual administration but is merely temporary in nature. In conclusion, Your Excellencies, we submit that the sale and seizure of the Falcon are unlawful on two grounds. First, that it violated the principle of state immunity when it seized a state asset that is used exclusively for governmental non-commercial purposes. Second, that the Transitional Council lacked the legal authority to waive the Falcon's immunity, as it was an unconstitutional entity acting beyond the framework of Ambrosia's constitution. We therefore urge this court to affirm the inviolability of state immunity by declaring that the sale and seizure of the Falcon was illegal. And second, we pray for this court to order the restitution of the Falcon back to Ambrosia. Your Excellencies, if there are no further questions nor clarifications, I thank this court for its time and its indulgence, and may it please this honorable court.
The semifinals competition continues when the Jessup 2025 Philippine Round Journey returns. Next, we move to the Respondent. The first speaker will present the first and second issues.
Madam President, Your Excellencies, good day, and may it please the court. My name is Yovelita Lubio, appearing as the first agent for the Respondent. Madam President, Your Excellencies, good day once again. In today's proceeding, this honorable court is faced with this pivotal question. Can this court extend its jurisdiction beyond the clear limits of state consent? In attempting to address this issue, applicant forwarded two arguments. First, on jurisdiction ratione temporis, and second, on jurisdiction ratione materiae. Your Excellencies, respondent submits that the facts or situations that gave rise to the dispute is the involvement of Ms. Cross in the crime of enforced disappearance under the ILSA program from June 2017 to July 2018, seen in paragraph 50 of the facts. This arrest and prosecution of Ms. Cross was the result of such involvement in the ILSA program, and consistent with the ruling of this honorable court in the certain property case in 2005, where it held that the decisions of the German courts cannot be separated from the settlement convention and the Beni decrees of which it is the result.
Anyway, Ms. Agent, let me get it correct from you. When you argue that this court has no jurisdiction to entertain Ambrosia's submission because it's outside the scope of the compromissory clause, is it either one or the other of the exercise of the instances when this court can exercise jurisdiction over cases?
If Your Excellency...
I know you've mentioned something about the acts having done or committed before the entry into force. So can you go into that?
if Your Excellency is referring on whether the limitations under Article 21, Paragraph B applies in this case?
No, whether it is the fact that the acts happened before the entry into force of the OCDP Charter, and or because it is essentially a domestic matter. So which is it? Of course I know that it could just be one of the two, or unless you're telling us that it's for both. No, you are arguing that neither or both of these the court really lacks jurisdiction. So I just wanted to get correctly from you.
Respondent submits that both exceptions apply in this case, Your
All right,
Excellency.
try to convince us then.
Turning to the issue on jurisdiction ratione materiae, Your Excellency's applicant earlier submitted that this is already outside the domestic jurisdiction of Ravinia, since first, this involves a foreign national, second, that this already involves immunity, and third, there is already an extradition request. Your Excellencies, on the issue of immunity, this is merely a procedural defense, which is likewise affirmed by this Honorable Court in the 2002 arrest warrant case, which does not affect the subject matter of enforced disappearance. Secondly, Your Excellencies, on the issue of extradition, Your Excellencies, the character of the extradition treaty does not change the nature of the crime of enforced disappearance. This is also affirmed by this Honorable Court in the Anglo-Iranian Oil Company case, where it held that matters which are ordinarily within the domestic jurisdiction of the state do not lose its character simply because it becomes an object to an international agreement.
So you will not factor in subsidiarity into that equation, Agent? Your finding that it is not competent to prosecute this is based on what facts again?
First, as seen in paragraph 62 of the facts, when President Duterte has already made a statement that Ms. Cross is a loyal servant of the people and that the ILSA program she administered saved many lives. Your Excellencies, this already
So
shows
you will
bias.
hold that particular statement, I think, in a press conference or because it's not in some official statement, yes? It's off the cuff. You will hold that particular statement having been expressed by the head of government. You will hold it against the state in this matter.
Not that statement alone, Your Excellency, but the
What
facts
else can you
taken
point to?
together. Turning to paragraph 57 of the facts, where President Duterte has already demonstrated the breadth of his pardon powers. Your Excellencies, it will
Agreed. But he pardoned the Transitional Council. He pardoned Zabala. Did not pardon anybody related to ILSA, or am I mistaken?
indeed correct.
So
Your
it's just his exercise of his discretionary power of pardon that you're pointing to now as supporting the position that extradition will not serve any purpose.
Yes, Your Excellency.
Aside from that, the statement, aside from him wielding his own power of pardon, anything else?
As noted by Your Excellency Gonzaga earlier, that there was already sufficient evidence present in the hands of the Ambrosian Prosecutor General. However, as seen in paragraph 28 of the facts, the Ambrosian Prosecutor General dismissed the charges against Ms. Cross, citing insufficiency of evidence.
There was subsequent reopening, yes?
There was subsequent reopening, Your Excellencies.
But you're not willing to give them another chance.
No, Your Excellency.
Universal jurisdiction it is then.
Yes, Your Excellency, this is also affirmed by the United Nations General Assembly Resolution 45116 on the model of extradition treaty that states have to determine and examine first whether the requesting state is competent before it would extradite perpetrators of the crime of enforced disappearance. Turning now, Your Excellencies, to the
But
issue...
aren't enforced disappearances a domestic crime instead of an international crime? In this case.
In this case, Your Excellency, this has already been a domestic crime, as evident by the incorporation of Ravinia of the crime of enforced disappearance into its own Ravinian criminal code, seen in paragraph 61 of the facts. Your Excellencies, even assuming that this court has jurisdiction, Respondent is still prepared to argue on its merits. Under Submission B, this Honorable Court is called upon to answer this question. To what extent should the fight against impunity be limited by the international rules on jurisdiction and immunity? Respondent notes, Your Excellencies, that the applicant earlier misapplied the decision of this Honorable Court in the 2012 Belgium versus Cignal case when it held that there must be a nexus before universal jurisdiction could be required. Your Excellencies, Article 9, Paragraph 2 of the Enforced Disappearance Convention is clear that what is only required by the prosecuting state, or there are only two requirements. First, that there must be a legislative mechanism, and second, that the offender is present within its territory.
The semifinals competition continues when the Jessup 2025 Philippine Round Journey returns. The respondent's second speaker now takes the floor to present the third and fourth issues.
Madam President, Your Excellencies, good day, and may it please the Court. My name is Bilyonaryo, and it is my honor to represent the respondent state, the Republic of Romania. Over the next 22 minutes, I will address respondents' submissions C and D pertaining to the issuance of fishing licenses in the Triton Shoal and the seizure and sale of the Falcon. The United Nations Convention on the Law of the Sea, or UNCLOS, grants to all states the freedom of fishing in all parts of the high seas. When Respondent began issuing fishing licenses for yellowfin tuna in 2018, the entirety of the Triton Shoal had already formed part of the high seas. The important question before this Honorable Court is simple. Does international law permit states to permanently fix their baselines? On this point, Your Excellencies, the respondent submits to the negative. The applicant, however, argues that it can validly legislate the permanency of its baselines under three arguments. First, that the freezing of baselines is consistent with UNCLOS. Second, that there is a regional custom. And finally, that it is consistent with the principle of equity. For the purposes of these proceedings, Your Excellencies, I will address these in turn. Turning to the first argument on the validity of their 2015 baseline freezing law. Your Excellencies, Article 5 of UNCLOS suggests an ambulatory character to normal baselines when it defined the same as the low water line along the coast. The respondent, however, understands that it is limited by the proviso, and I quote, as marked on large-scale charts officially recognized by coastal states. And so therefore, Your Excellency, the applicant hinges its discussion that there is no obligation to update baselines.
Agent, don't you think coastal states have a right to establish their own exclusive economic zones?
States indeed have their rights, Your Excellency, to establish their exclusive economic zone and other maritime zones for that matter. However, this is limited by the express provisions and
in which case that's what the applicant did. It just established its exclusive economic zone.
Your Excellencies, we need to clarify what low water line means and whether there is an obligation to constantly reflect the actual low water line. And at this point, Your Excellencies, there is a need to address or review the drafting history of what was to become Article 5 in order to determine whether states are indeed permitted to fix their baselines at a certain date. In the 1930 Hague Conference, the Subcommittee on Territorial Sea defined normal baseline as only valid when it does not, and I quote, appreciably depart from the mean low water spring tides, end quote. This was carried over in the 1952 and 1954 meetings of the International Law Commission.
But is it not that these covenants have been fixed way before the climate change. So shouldn't we adhere to new treaties or new agreements?
Don't you think the principle of rebus sic stantibus applies in this case? Because there is a change of circumstances, and the main change of circumstances involve the rising waters, the rising seas.
What is the present law, state of law, international law or practice or on this matter? The effect of climate change, as already mentioned. Is it not already recognized? I mean, there's that convention, what's that, the international, something it is mentioned here. The IP.
The OCDP Charter, Your Excellency. To answer first, Madam President and Your Excellency Villasor's questions together, the respondent submits that there is no occasion for the application of the principle of rebus sic stantibus in accordance with Article 62 of the Vienna Convention on the Law of Treaties. But if this Honorable Court is not persuaded that these circumstances are already apparent by 1982, one of the other cumulative conditions is that it must have constituted the essential basis of the consent of the state to UNCLOS.
But we have already, I think, agreed. I have
The OCDP Charter.
yes, all of these.
Your Excellencies, we do recognize our obligation under Article 1, Paragraph C of the OCDP Charters, which requires the sustainable management of resources in the Aegean Sea and their proper allocation between member states, and the respect for the maritime rights of the other states. However, Your Excellencies, this is merely a general obligation which has to be assessed in light of the express provisions of UNCLOS, which constitute the more specific law on the matter. And in this case, Your Excellency, it is the respondent's submission that Article 5 still espouses an ambulatory nature to normal baselines.
But also on the fact that all the other states in the Plain Peninsula had already their own baseline freezing law, and it's only your state, Slovenia, who has not issued it. Why should you not be bound by what has been passed by all the other states under customary law?
Because, Madam President, on the first level, there is no regional custom in the first place. And Your Excellency Docena was correct earlier in asking for the standard for regional custom. And this is provided in the 1950 asylum case between Colombia and Peru. In that case, Your Excellencies, this Honorable Court stated that a state asserting the existence of a regional custom must establish that it is supported by consistent practice and usage by all the states in question.
But that's not necessarily accurate. That is by all. It is there should really be mentioned that everybody will agree. I think that what has been said or stated was that at least as a majority or substantial number. It's really not an all thing.
Your Excellency, allow the agent to clarify. In cases of general customary international law applicable to all states, indeed, unanimity is not required. What is only required is especially the practice of specially affected states. However, in the case of a regional or particular customary international law, which is what is being alleged by the applicant, there is a requirement of unanimity, considering that it merely involves a limited number of states. And a state which has not
Is not
acquiesced...
substantial compliance or substantiality acceptable?
That may indeed one way of viewing it, Your Excellency. However, even on that regard, the respondent still submits that in occasion where there is already a regional custom, it is nevertheless a persistent objector to the same. And the standard for this, Your Excellency, is found in the 1951 Anglo-Norwegian fisheries case, where this Honorable Court held that for a state to exempt itself from the application of a regional custom, it must have, and I quote, consistently and persistently objected to said practice during and after its formation.
Is that a consistent series of objections then? Because earlier, issue was taken with the fact that there was no response from a particular state.
To address Your Excellency Gonzaga's question first, the respondent does recognize that its delegate abstained in the March 6, 2023 resolution seen in paragraph 33 of the facts. However, to clarify, Your Excellencies, this abstention did not amount to acquiescence. Your Excellency, our refusal to revoke our land licenses and our continued issuance of fishing licenses is a continuing objection to such claim by the applicant that it had sovereign rights over parts of the Triton Shoal, and therefore it need not express another or separate objection, considering that it had still annually objected to the practice. This leads the agent to the fourth and final submission pertaining to the seizure and sale of the Falcon. Your Excellencies, the important question under submission B is simple. Does a de facto government in effective control override the governmental claims of a constitutional claimant to governmental status? And in this point, Your Excellencies, the respondent submits that there is no preference for constitutional or democratically elected governmental claimants in cases where there is a rival unconstitutional claimant in effective control.
Agent, has the Transitional Council been recognized?
By the respondent state, Your Excellencies?
Yes.
It was indeed recognized by the respondent state, Your Excellency, as the government or legitimate representative of the applicant state.
But by the international community of nations?
It was recognized by 25 states, Your Excellencies, as seen in paragraph 49 of the facts. And in that case, Your Excellencies, the greater number of states have actually preferred to recognize effective control over constitutional legitimacy on account that they recognize that it is only the entity ineffective to control who can carry out the obligations of the state or the government in situ. And in this case, Your Excellencies, not only does the Transitional Council have the habitual obedience of the people, it also had the acquiescence of key state organs. In paragraph 47 of the facts, Your Excellencies, we can see that the key members of the executive and legislative departments, as well as the police, the military, and the intelligence community, had already supported the Transitional Council.
Can you cite cases decided by this court where de facto governments have been acknowledged and that they are justified to do a waiver of immunity?
None so far, Madam President. However, the respondent submits the case of the Tinoco arbitration, for example, arbitrated by Chief Justice William Howard Taft, where he stated that a de facto government is entitled to recognition and his acts entitled to same recognition if that particular entity has in actual control over the state's population, organ, and important state officials.
So how can you convince us to consider the waiver of immunity done by the council, by the Transitional Council?
The waiver, Madam President, should be considered as having satisfied Article 19 of the UN Convention on Jurisdictional Immunities of States and their Property. And this is one of the conditions, Madam President, under which the immunity from enforcement of a state property may be dispensed with. This ends the submissions of the respondent. Thank you, and may it please the court.
Advancing to the national finals, the applicant, University of Santo Tomas, wins the match.
Feels really good, and this feels like such a historic moment for the organization and the university. And we really want to acknowledge our coaches who dedicated all of their time to help us out.
Yung sense of fulfillment doon na finally, yung mga times na nag-training kami right after classes, 10 p.m. until 2 a.m. in the morning, diba, na nasuklian din naman.
University of Santo Tomas now claims the first spot in the championship round of Jessup 2025. The semifinals competition continues in the next episode of Jessup 2025, the Philippine Rounds Journey.